A Trust Guide to Protect Money. Chapter 1. Trusts Info. Using trusts to protect assets. People at all socio-economic levels use trusts for asset protection purposes and for other reasons. There are many different types of trusts. Only a few are useful for asset protection. A settlor/grantor creates a trust. He or she provides the funds and other property that will be held in trust. Think of it that way, as money and property held in trust for some reason that will occur at some future date. The grantor sets the terms under which the items in the trust will be managed and distributed. This grantor names one or more trustees which, in some cases, could be the grantor himself but is often someone else. The grantor also names the beneficiaries of the trust, people or organizations who will get the proceeds from the trust. With some trusts the grantor can be the trustee and the beneficiary, as with the living trust, a common tool of asset protection. There are two basic classifications of trusts. Inter vivos testamentary. Irrevocable inter vivos trusts shelter your assets from your creditors. Testamentary trust, if done properly with the right provisions, can protect the trust assets from the beneficiary's creditors. A living trust is created during the grantor's lifetime. It is an inter vivos trust because it is funded while the grantor is alive. Testamentary trusts are trusts that are created while the grantor is alive but don't get funded until the grantor dies. Another classification of trusts is as follows. Revocable. Irrevocable. The grantor can change or revoke a revocable trust while irrevocable trusts cannot be revoked or changed. Testamentary trusts are irrevocable because they were made by a person who is now dead. Revocable trusts do not provide asset protection. Irrevocable and inter vivos trusts are the types that can help you for asset protection. There is a disadvantage in creating such a trust. Once you create it and fund it, you permanently lose the ability to revoke it and reclaim whatever property you put into the trust as your personal property. The trust becomes the owner of those assets and the trustee becomes the controller of the trust. This is a strong disadvantage, which is why irrevocable inter vivos trusts are rarely used for asset protection. Think of it this way. Creditors can come in and change your revocable trusts in such a way that they get their money. With an irrevocable trust, your creditors cannot come in, undo it and reclaim its assets. With an irrevocable trust, until you actually fund it, thereby relinquishing control of your assets to the trust, those assets are your personal property. Then when you fund it, the trust owns them, not you, and it is unchangeable. Some states don't allow trusts to be created exclusively for the benefit of the grantor. There must be other beneficiaries. He can put a provision in saying that he can take some money out if he needs it as with an unforeseen medical emergency, but to create a trust for yourself just to protect your assets from lawsuits and creditors is not possible in all states. There is always the fraudulent transfer bit, transfers deemed fraudulent under the Fraudulent Conveyances Act, where creditors can claim that you transferred assets into a trust to avoid paying your debts. If a court finds this to be the case, they will revert the assets back to you, whereupon your creditors will take what is owed to them. This applies even to irrevocable trusts. They protect the assets from future creditors but not from present ones. If you have debts or a lawsuit against you and you transfer a bunch of your assets into an irrevocable trust, it probably won't work. They will deem it a fraudulent transfer and those assets will revert back to you to be taken by your creditors. In order to use trusts to shelter yourself from your creditors, you must use an irrevocable trust and do not transfer assets into it in such a way that it can be deemed as a fraudulent transfer. The trade-off is a surrender of control and ownership in exchange for asset protection. If these are assets that you won't really need to live comfortably for the rest of your life, why not get it over with? Get an irrevocable inter vivos trust which will spell out where the money goes upon your death, probably to your children, thereby shielding those assets from creditors or lawsuits. When making up an irrevocable inter vivos trust in order to protect your assets, don't put in clauses in giving you the power to revoke it or transfer your assets back to you, because if you do, it opens the door for creditors to go after those assets. As an irrevocable inter vivos trust grantor, you cannot be its trustee nor use someone close to you as a trustee. Unless the trustee is an independent person, not connected to you personally, the courts will allow the grantor's creditors to go after the trust assets. Use a bank or a financial services company as your trustee. As an asset protection device, limited partnerships are better because they are revocable and, as the general partner, you have control over the assets. Revocable trusts are more common than irrevocable trusts. They are useful in estate planning but have no asset protection value since creditors can go after any assets that you transfer to a revocable trust. In most states but not all, they just have to ask the courts to transfer the assets back to you. Chapter 2. Other types of trusts. Marital Life Estate Trust/AB Trust. A marital life estate trust, commonly referred to as the AB Trust, is set up by couples while both are alive whose combined estate is in excess of the $2 million exemption from estate taxes for every individual. When one of them dies, the trust is divided into two trusts. An irrevocable trust. A revocable trust. The living spouse owns the revocable trust which she can manipulate and spend at will, and she can also withdraw money from the irrevocable trust even though she is not the technical owner of it. The irrevocable trust is a trust, therefore not a part of the probate process. She uses the money from both trusts, then when she dies, the money is passed on to the beneficiaries without going through probate. The marital life estate trust lets both spouses take full advantage of the $2 million estate tax exemption, so they're exempt from federal estate tax up to $4 million. The survivor never becomes the legal owner of the trust. If legal ownership is never bestowed, then the property is not included in the survivor's estate and thus avoids being counted for tax purposes. When the surviving spouse dies, the money goes to the beneficiaries named in the trust. The trust is complex and has important ramifications for the surviving spouse which should be understood before putting this type of trust into effect. Asset protection trusts. If you live in a state with an inheritance tax, you might want to take a look at asset protection trusts that several states have, among them Alaska, Colorado, Delaware, Nevada, and Rhode Island. Think of these asset protection trusts as a domestic form of the offshore trust geared to help protect your estate from taxes and your assets from creditors and lawsuit judgments. Do some research to determine if an asset protection trust in any of these states is better for you than setting up a trust in your state. These asset protection trusts could be better than an irrevocable trust in your home state, but offshore trusts are ultimately superior for asset protection because as long as your money is in the United States, the IRS can basically do what it wants and others can file charges of fraudulent transfer against the assets in those trusts which, if proven, leaves your money open to creditors. If your money is in another country, they don't recognize American laws. It's safe there. My advice is to consider investigating the trust laws of these states with your estate planning advisor/attorney, but never forget that your money is never completely safe unless you have cash hidden in a safe place or it's in an offshore account. The shortcoming with domestic asset protection trusts is that even with a trust from a more protective state, you are still not protected from the claims of current creditors. Just like the Nevada Corporation is considered king as the place to incorporate because it has the fewest and laxest laws, so too is the Nevada Trust considered the most protective domestic trust based on a minimalist practice of imposing rules and regulations. Bypass trust info. A bypass trust is simply a trust you make up where you allocate a certain monthly income to your spouse or someone else until their death, then stipulate that the money goes to someone else, not into her estate. Thus, you bypass the possible estate taxes you would have paid if you had simply willed the money to her and it was added to her estate. Children's trusts. A spendthrift trust is a trust made out for unwise or frivolous heirs, children, in order to put conditions on the disbursement of the money by the trustee so as not to give them the money in a lump sum such that they will waste it. Trusts for children are somewhat different because they are made for children only and expire at 21. You're doing it because you want to help your children financially, plus it can possibly reduce your taxes and give you asset protection by disposing some of your assets into the trust. A children's trust, sometimes called a crummy trust, can be used to allocate money to your children according to your wishes, such as monthly or for a specific purpose like education or to buy a house. You're allowed to sign over real estate property to a trust that the trustee manages on behalf of a child. However, in this case, the trustee is not allowed to also be the child's legal guardian. The advantage to creating an irrevocable children's trust/ICT besides gifting money to your children is that the money leaves your estate, therefore it is not taxable as part of estate taxes, and this money cannot be seized by your creditors. Some income from the trust can be taxed at the children's income tax rates. The ICT is sometimes referred to as the Section 2503 Minors Trust, which sets out the rules. The ICT is like any other trust with a trust document, a trustee, and conditions for disbursement. Since the trust is irrevocable, the grantor can't touch it after he has created it. While the beneficiary is under 21, the child's creditors, if he has any, cannot claim the trust assets. When the child hits 21, he or she has the right to withdraw all the assets if they want to. The grantor is out of the picture. It is a child's trust, only applicable to children. The only way you can keep the money in the trust is if the child agrees to it at age 21 by putting it in writing. The negative effect of children's trusts is the possibility that a 21-year-old gets all that money and spends it foolishly. Income trust info. You set up a trust made up of stocks, mutual funds, real estate, etc. Every month the presumption is that this income trust earns money, so you allocate a monthly income to the benefactor of the trust. en.wikipedia.org/wiki/income_trust. IncomeTrustResearch.com. Investcom.com/incometrust/incometrust.htm. Investopedia.com/terms/r/royalty-income-trust.asp. Irrevocable life insurance trust. Life insurance is considered by some people to be a valuable estate planning instrument because a person can accumulate a substantial cash value which will be payable immediately to the heirs upon death without the hassles of probate hampering it. Life insurance can also be used to pay estate taxes, which, in some cases, can save the heirs from having to sell a house, farm, or business in order to pay these taxes. If you own a significant amount of life insurance, then you might consider protecting it by putting it into an irrevocable life insurance trust/ILIT. An ILIT has the same basic structure of any other trust with a grantor, trustee, beneficiaries, and discretionary clauses for trust distributions. The ILIT becomes the owner of the insurance policy. The beneficiary would be named in the policy as opposed to the trust. When you pass, the insurance company pays the trustee, who then follows the instructions of the trust and distributes the proceeds according to your wishes to the beneficiaries named in the trust. There are generally two types of ILITs. Funded. Your life insurance policy is all paid up and stays that way until you pass, then the money is paid by the insurance company and the money disbursed by the trustee. Unfunded. You still owe money on the policy and must make regular payments through the trust, which now pays the premiums in order to keep it legal and active until you pay the full amount or die, in which case it kicks into your beneficiaries. Policy payments must be made directly from the trust as opposed to from the grantor through the trustee. This is a quirky little rule that must be followed in order to keep the ILIT valid. Because the ILIT is an irrevocable trust, the policy's cash value and the proceeds on distribution are protected from both the grantor's and beneficiaries' creditors. If you're into life insurance as an estate planning device and your state laws don't protect law insurance proceeds from creditors or lawsuits, then you should check into an ILIT. It will protect the policy and save on estate taxes because it will be the ILIT, not you personally, who will own the life insurance policy, therefore it's not a part of your taxable estate. If you're wealthy, this could save you a lot of money in estate taxes. With an ILIT, you also have more control over the disbursement of the policy than when you own the life insurance policy personally in your name. With a personal life insurance policy, the insurance company pays your beneficiaries straight out in a simple transaction when you pass, but with an ILIT, you can set conditions and clauses for your trustee to follow, such as a gradual disbursement over time as opposed to a lump sum payment, and other things such as paying estate taxes first before the trustee passes the money off to the beneficiary. Finally, a little-known loophole that many insurance companies use to sleaze out of paying life insurance proceeds is that they refuse to pay life insurance proceeds to an incapacitated person. They say they want instructions from the court and hope that it gets buried under a ton of paperwork. With an ILIT, you will have no such problems in the unlikely case that a beneficiary goes incompetent either due to an accident with brain damage, Alzheimer's, etc. cashbazaar.com/insurance.html. Land trusts. Land trusts are used in about a dozen states like California, Colorado, Florida, Georgia, Illinois, and a few others. A grantor can put any real estate he wants into a land trust, including his own home and raw land. A bank or trust company often acts as the trustee. Put in whatever clauses or provisions you want on the property as long as they are legal and ethical. You make yourself the trust beneficiary. The trustee controls the real estate according to the provisions you set up. Because you own a beneficial interest in the trust, this is your personal property, therefore not protected from creditors or a lawsuit judgment. A way around this is to title your beneficial interest to a business entity like a limited partnership, limited liability company, or to an irrevocable trust. Don't expect it to be easy to get either a mortgage, second mortgage, or an equity loan on any real estate in a land trust. Banks like the ownership to be one person or a clearly defined, visible company that does business in the community, unlike an LLC that doesn't seem to do much of anything but own some property. Any savvy loan manager would be suspicious that all is not right here. People generally get land trusts because they want privacy. Their names do not appear on the public record real estate documents. This may or may not protect them from creditors who might or might not find out that they own this land through these trusts. This privacy might give you some kind of asset protection. Medicaid trusts. A Medicaid trust is useful to an older person who may need long-term medical care at a nursing home. Rather than use your assets to pay for this expensive medical care, you title them to a trust for your wife and kids after you pass, such that you have very few visible assets, and government Medicare through the Medicaid program for low-income people pays for your medical care. A Medicaid trust is an irrevocable trust. You transfer your assets to this irrevocable trust, but unlike other irrevocable trusts, you, the grantor, can take out a certain amount of money every year as an income beneficiary up to the amount allowed by Medicare. Then when you pass, your children or surviving spouse become the beneficiaries. Medicaid trusts do not allow the grantor to use the trust assets for other health care purposes, only long-term care. The rule is that you must create the Medicaid trust at least 60 months, 5 years, before you apply for Medicaid. It's not that hard to foresee. If you feel yourself starting to degenerate physically at about the age of 60, you might as well set up a Medicaid trust to anticipate the day when you will be in a nursing home or have some other assisted living care. Qualified Personal Residence Trust /QPRT. A QPRT is a trust that grantor sets up to transfer his primary residence to his house. He sets a term in which he will be the resident of the home, tenancy, after which the house goes to his beneficiaries. The term cophold be for life, then the house passes on. The purpose of transferring your house to a trust now is to reduce estate taxes later because it won't be part of your estate. Transferring the house to a QPRT won't protect the equity the grantor has in it, his right to live in it for X number of years. The creditor can take this, rent out the units or live in it, but at the end of the time period, the house will go to the beneficiaries. At the end of the term, the trustee either gives the residence to the beneficiaries, sells the house and gives them the money, or converts the money into an annuity which is protected from creditors in most states. Qualified Terminable Interest Property Trust /QTIP. A QTIP, Qualified Terminable Interest Prosperity Trust, is primarily used to give a second or third wife money until her death in monthly installments in order to prevent her from squandering the estate. If the husband dies, he can leave assets in a QTIP trust to be used by the current wife for the rest of her life with only a monthly allowance and no lump sum, so he's preventing her from squandering it and ordering whatever's left when she dies to go to his biological children. Human nature says you take care of yourself and your own first. If a man dies and his second wife gets a lump sum, she will spend most of that money on herself and her children rather than give it to the man's biological children who are living elsewhere with the first wife. This is why you get a Q-tip, to stop your last wife from keeping all the money for herself and in the process cutting your biological children from another marriage out of the deal. The trustee may be asked to use his discretion as to how much money to give to the parties involved, or it may be a fixed monthly amount. If you remarry and you have children from a previous marriage, the biological ex-spouse gets those kids, her biological children. If you die, so make a living trust to leave the money specifically to them and cut both wives out of getting your assets. You can use a Q-tip to cut your last wife off in the event that she remarries and leave the money to your children from that point on. Just put a clause in the trust stating this. Q-tips can also be used to temper a first wife who might be greedy, frivolous, or mean. You give her a bit of money but leave the bulk of it to your children, thereby bypassing the possibility that she could hoard all the money for herself and not help the children out much. By IRS rules, income from the Q-tip must be used solely by the surviving spouse during her lifetime. Only when she passes does it revert to the children. This is necessary in order to qualify for the unlimited marital deduction. Estate taxes are deferred until the surviving spouse passes. Because the Q-tip is a testamentary trust, which, by definition, takes effect only upon the grantor's death, there is no credit protection for the assets in it from creditors. When the surviving spouse starts collecting money from the trust after your death, what she gets in her hand monthly is not protected from her creditors, but the main balance of the trust is. An alternative to the Q-tip is the irrevocable inter vivos marital deduction trust, which has the advantage of offering greater asset protection than the Q-tip. If the man or woman of the house is in danger of losing major assets through creditors or a lawsuit, put these assets into an irrevocable inter vivos marital deduction trust in order to protect them. In legal terms, this is equivalent to giving a gift but could be subject to a charge of fraudulent transfer, so be careful about doing it. If you later divorce this person to whom you've gifted your major assets to, that's too bad for you. You lose legal ownership. Special Needs Trust Info. A special needs trust, also called a supplemental needs trust, is a trust which is designed to provide benefits to and protect the assets of physically disabled or mentally disabled persons and still allow such persons to be qualified for government assistance. A special needs trust is created to ensure the continuation of government benefits. If you give a lot of money to your child in a will, this could disqualify him from collecting Medicare and Social Security disability money. Instead, you set up a special needs trust where your appointed trustee gives your child X number of dollars per month over and above his monthly payments from the government to enhance the quality of his life. See an attorney who specializes in special needs estate planning that allows to leave money for supplementary needs not covered by the government. Get grandparents and other relatives to put money into this trust rather than leaving it in a will. In Canada, this special needs trust is called a discretionary trust or a Henson trust. Every province has their own version of this trust, like Ontario with the Disabilities Expense Trust. If you form a trust, you need a trustee to manage the money in the trust. If you can't find a friend or relative to do it, the bank or financial institution can appoint a professional to do it for a fee. Some disability organizations like TheaRC.org operate something called a pooled trust. Check it out for yourself. NSNN.com, National Special Needs Network. en.wikipedia.org/wiki/special_needs_trust. seniorlaw.com/snt.htm. The Spendthrift Trust. A spendthrift trust can be a good idea if your beneficiary is too young, does not have the mental capacity to handle money, or is simply a frivolous, unwise adult who would probably squander the money if he or she got it all in one shot. The trust can be established so that the beneficiary receives small amounts of money at regular intervals like monthly. It prevents the person from squandering money or losing the principal in a bad investment. As an added bonus to creating such an irrevocable trust, you also protect the assets in it from your beneficiary's creditors, lawsuits against him or her and ex-spouses. Irrevocable trusts may be either inter vivos or testamentary. You can either put money in while you're alive, inter vivos, or set it up as a testamentary such that it will be funded from your assets upon your death. Trusts for inheritances. One great thing about trusts made out to beneficiaries like your children is that if they get sued or rack up bills either before they're collecting disbursements while you, the parent, are alive, or are collecting money from the trust after you pass on, is that the money in the trust is lawsuit judgment and creditor proof. If they take the money out and buy a fixed asset like car or shares in a stock, then it's unprotected, but as long as it's in the trust, it's untouchable. Put an anti-alienation or spendthrift clause into your trust which specifically protects the trust from the beneficiary's creditors. The anti-alienation and spendthrift clauses forbid the trustee from giving money in the trust to anyone other than the beneficiary, which includes creditors. There are some exceptions though, depending on the state you live in. In some states, a spendthrift or anti-alienation clause will not protect a beneficiary from bankruptcy, divorce or tax claims. Just don't forget, if you as the beneficiary/heir, have some kind of judgment against you, be very careful with what you do with the money once you take out your yearly allotment in a lump sum or however the trust works. Get it in cash or send it to a foreign bank account immediately. Creditors have computer programs that spit back to them a short report anytime your name is involved in some kind of bank or credit transaction, so they know if you've recently had some money transferred to your account, started an account, bought a car, paid with a check, etc. Another way that you, the creator of the trust, can help the beneficiaries out from creditors is to grant the trustee a discretionary clause which gives him or her broad discretionary powers with the specific instruction that if the beneficiary has creditors hounding him, hold off until another time to give them money when it's more safe. The beneficiary could be going through a divorce or have creditors waiting for him to get some money. The trustee simply wisely decides he will not give the beneficiary any money at this time. If you worry that you have a child who is either frivolous, unwise, or on drugs, you can minimize your worries that the child, your beneficiary, will waste the money in the trust once he gets it by putting in a provision that the trustee will withhold money until such time that he sees the beneficiary acting in a responsible manner. Your definition of responsible manner can be anything you see fit. You can demand clean drug and alcohol tests quarterly for a year, demand that the beneficiary hold down a job for at least 6 months, be married, have a biological child, etc. You could have a responsible child but he or she may be polluted by a spouse who is a spendthrift, wants to take the money and waste it. At the very least, put in a clause stating that if the child dies or divorces, the assets are not passed on to the wife if the trustee deems her a spendthrift/frivolous, unwise person. It passes on to the child's kids at 18 if he has any or to other relatives. You can even put provisions in for future grandchildren or any other beneficiary you want. If you as a beneficiary have a creditor hot on your tail, have your trustee pay you in cash or when you get the check, take a short trip to another stable country like Canada and open an account there. Another method to keep the creditor at bay is to have the trustee put the money directly into the account of a relative or a trusted friend, then this person can disburse it to you in cash for a small fee for their troubles. Rather than an inflexible regimen of disbursing assets such as a fixed amount of $50,000 a year for 20 years, a sprinkling provision is a provision that gives the trustee the right to disburse the assets as he sees fit in the best interests of the beneficiary. If the trustee thinks the beneficiary is going through a hard spell, he will give him extra money provided he's not drinking it away. If he's doing well financially, he might hold off giving him money to reduce his overall tax burden since trust money is counted as income on a tax return. As the creator of the trust, think it through and write down the specific points you want your trustee to follow in giving money to your heirs later on. Simply call your points discretionary clauses. You can generally put any conditions on the trust you want within reason, common sense, and ethics. Asset protection trusts that you make for your children must be irrevocable, therefore free from being changed by the grantor. A beneficiary is not allowed to be a trustee because if he or she is, the assets in the trust that are due the beneficiary then become vulnerable to creditors. That's the law. If you have a nasty spouse or your wife is the stepmother as opposed to the biological mother of your children, protect your money by writing up a trust for them rather than leaving it to her, trusting her to pass it on to them equitably. Get a trust with anti-alienation, spendthrift and discretionary provisions. With an irrevocable trust to your children, you protect your money in the trust from your own creditors while gifting them tax-free to your children, reduce your estate taxes and protect the trust fund assets from your children's creditors. Other types of trusts. There are many types of trusts. You can use your creativity to create one that applies to you. The most important factor is to find the right expert to make up the right trust for you. Beware of the many sham trustee experts out there who give misleading advice about trusts that are not legal. Don't be sucked into paying several $1,000s to set up a simple trust. Buy a good book and possibly consider setting it up yourself with blank forms you can buy at stationery stores. You shouldn't attempt to set up every conceivable type of trust. The key is what your estate and heirs picture looks like. This will govern the estate planning devices you will utilize. A few examples of trusts are: accumulation trust. A trust that does not pay out all of its income until certain circumstances occur, like age milestones. Credit shelter trust. If you know your estate is going to go over the current federal exemption for death taxes, about $1.5 million per person or $1.7 million per couple, you can create this type of trust to take advantage of the federal law which allows you to give away $1.5 million during your life tax-free. Simply make up the trust to save on estate taxes. Generation skipping trust. You may have heard of this type of trust where the bulk of assets are left to the grandchildren but the income derived from them is utilized by the trustor's own children. In essence, the estate skips the children, going directly to the grandchildren, but the use of the income is still there for the direct heirs, the use of the property is not. The government imposes a flat 55% tax on everything you leave to your grandchildren's generation in excess of $1 million. If an estate is worth more than that, the children may want to get this excess property directly since they will have no access other than the income from the property that was transferred to the grandchildren. It all depends on the size and type of estate. Grandparents' trust are trusts set up by grandparents for their grandchildren, usually for education. A grantor retained income trust is a trust where you transfer ownership of your home to a trust and continue to live in it with the stipulation that when the trust expires, it goes to your children. A life insurance trust is used to give your estate liquidity and prevent the proceeds from being counted as part of your estate. Proceeds from a life insurance trust pass directly to your beneficiaries without probate. The proceeds are administered by a trustee for your beneficiaries. Life insurance payouts are not subject to federal income tax but are subject to estate taxes, but if you structure your life insurance trust well, you won't have to pay these taxes. The trust also protects the insurance proceeds from creditors and malpractice litigants. Call 800-MetLife, metlife.com, for more information. They can sell you such a policy. Qualified Personal Residence Trust, QPRT, enables you to take your home or vacation home out of your estate by giving it to the trust. You continue to live in the house, then when you die, what happens to the house is determined by what you stipulated in the trust and you avoid paying estate taxes on it. A testamentary trust is a trust that is created as a result of orders you impose in your will. Payable on death bank accounts, also known as Totten trusts or the poor man's trust, are merely bank accounts or government securities where you ask for a form where you sign to transfer the account to one beneficiary only upon your death. Just ask about them at the bank. There's no probate involved. Chapter 3. Trust Resources. Trust Journal. Trusts and Estates Magazine. 6151 Powers Ferry Road, NW. Atlanta, Georgia 30339. 770-618-0211. napc.org/membership/benefit/27. Also a directory of trust institutions. en.wikipedia.org/wiki/trusts_ampersand_estates_left parenthesis journal right parenthesis. Trust websites. CompleteTrusts.com. FinancialIntermediary.org. FTCI.com, Fiduciary Trust. ftc.gov/bcp/conlani/pubs/services/live-trust. fultonfinancialadvisors.com/institutional trust. investmentcarch.com, investment trusts. investorprotection.org/faq/foi.html, investor protection trust. livingtrusts.net. mylivingtrust.com. premieradministration.com/crewt.htm, tax-exempt trust. revistrust.com/pages/topic_2.html. trustbabies.com/advantages.htm, trust funds for babies. trustnet.com. trustsandestates.com. trusts-and-trustees.com. tunu.com/trustsubt.com/trustsite/resource_library. Trust forms. 1stoplegal.com. accesslegalforms.com. findlegalforms.com. freebusinessforms.com. legalzoom.com. living-trustforms.com. mytrustforms.com. nalo.com.